Major breaking news, although in many respects it's not news because we knew what was going to happen in the Court of Appeals for the 7th Circuit out of Chicago in a 2-1 decision. The anti-gun judges of Judge Diane Wood and Judge Frank Easterbrook, two people that are perfectly situated for a high school moot court judging contest, unfortunately sit on the 7th Circuit and have ruled that Illinois' quote-unquote assault weapon ban of semi-automatic weapons and magazines that hold more than 10 rounds is constitutional under the Second Amendment, denying the preliminary injunction sought by those that wanted to stop the Illinois law. This is not a shock. This is what I predicted repeatedly because I saw that panel of Judge Woods, who was a Clinton appointee and on the short list for a Democratic appointment to the Supreme Court, and Frank Easterbrook, who always wants to sit on the Supreme Court. They're both bitter judges, in my opinion, and they behave as such. And this opinion, as an inferior court judge, thumbing their nose at the Supreme Court is further proof that they're sitting in their corner, sucking on their metaphorical thumbs, crying that they're not on the Supreme Court. But unfortunately for them, they're not on the Supreme Court, and they're not following Supreme Court precedent, and this is going to backfire on them big time. Stay tuned. Hey folks, I'm Mark Smith, host of the 4Box, a Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on audiobook and Kindle, and of course, paperback. All right, folks, so unfortunate news, although not unexpected. The United States Court of Appeals for the 7th Circuit out of Chicago, in a 2-1 decision, has denied the request for a preliminary injunction to enjoin, which means to stop, the enforcement of Illinois' so-called assault weapon ban, which are firearms, semi-automatic firearms, semi-automatic rifles, and magazines that hold more than 10 rounds. I won't get into the details of that. I think a lot of you know that. But the bottom line is, in this 2-1 panel, Judge Wood, Diane Wood, a Clinton appointee, and Judge Easterbrook, who's a bitter older man who's upset he's not on the Supreme Court in a 2-1 decision, have ruled against the Second Amendment. Michael Brennan, a Trump appointee, dissented completely and says that they're off on their application of law, and he is clearly right. I will get into the details of this opinion in just one second, but I will say overall, having read this set of opinions, which is about 97 pages long, that's right, 97 pages long, it is clear to me that the opinion by Judge Wood, signed off by Judge Frank Easterbrook as well, is not a serious piece of legal scholarship. When I read this, I really felt as if these people were trying to get tenure at a university somewhere or wanted to do a term paper so they could get some sort of a degree in college. So it reads very well at that level, but in terms of following the Constitution, following the text of the Second Amendment, following the basic application of how you interpret the Second Amendment, I can tell you that most of the people that watch my 4Box a Diner channel religiously would do a better job writing this opinion than either Judge Wood or Frank Easterbrook, unfortunately. But again, we predicted this, and this is where we are, so let us go into the detail. To begin with, Judge Wood's opinion, and she's the one that signed the opinion, Frank Easterbrook agreed, specifically starts off with your typical boring pedestrian statement that the Constitution and the rights have limits. The Second Amendment, like all other rights, have limits. Okay, well, this is like a meaningless statement. We understand that all things have limits. A chair is a chair and not a couch. Even the word chair has limits, so what? But then he goes on to talk about how, well, obviously the Second Amendment doesn't protect the right to own a nuclear weapon. But again, who cares? We're not talking about nuclear weapons. We're talking about those firearms that Americans own to the tune of tens of millions. So then they go on and talk about how handguns are protected under Heller. I think it's someone, they even made a reference here that was somewhat like sarcastically by trying to say, well, we got handguns on the one hand, nuclear weapons on the other hand. All of this is, again, perfectly fine if you're a sophomore in high school, but not particularly fine if you're an inferior court judge, which is what you are under Article 3 of the U.S. Constitution. You're supposed to follow the precedents of the U.S. Supreme Court in Heller and Bruin, and although they paid lip service to this, it's pretty clear that they did not take it seriously, and I can promise you this, that the 6 justices on the United States Supreme Court who have ruled in favor of the Second Amendment in Bruin, they will read this decision by Judge Wood, and I can assure you, I promise you, they will not be impressed. They will roll their eyes and be like, oh God, Christ. And that's what they're going to say. Trust me, it will not be taken seriously. But nevertheless, let's talk about some of the fundamental mistakes in this opinion, because it is the law of the land in the 7th Circuit for the moment. So first of all, major mistake on the part of Judge Wood's majority opinion here, which is, again, they make a clear, obvious mistake where they elevate and confuse the textual analysis with the historical analysis. Specifically, they point out that Bruin, essentially say that The only arms that are protected under the right of the people to keep and bear arms are those arms that are not only something that can be used offensively and defensively, but also those that are in common use for self-defense. But this is clearly wrong. We've talked about this before. At the textual level, under Heller, anything that can be used offensively or defensively, or that can be used to facilitate self-defense, for example, is deemed an arm, as in the right of the people to keep and bear arms. Obviously, an AR-15, any kind of semi-automatic rifle, AK-47s, magazines, these are arms textually. Okay? So once the text is satisfied, which it clearly is here, you know what happens. The burden shifts. The burden shifts to the government. To do what? The government bears the burden to come forth with historical analog laws that justify their modern-day gun control law. However, and here's the key. You know from the Four Boxes Diner channel that there are two general cases involving the Second Amendment in America today. There are arms ban cases, and there are everything else. The reason why this is important is because all the historical spade work involving banning an arm, whether that arm be a knife, whether that arm be a handgun, whether that arm be a semi-automatic rifle, whether that arm be a bayonet, whether that arm be a magazine that holds more than 10 rounds, or any of these things. The legal test that's devised by doing the text first, followed by the historical analysis of American gun regulations, has been done for arms ban cases by none other than the U.S. Supreme Court in Heller. And what did the Supreme Court say? If an arm is in common use by Americans for lawful purposes, it cannot be banned, period, full stop. That's it. That's it. That is the test. But what happens here in this decision, in Bevis versus Naperville and the other consolidated cases, that Judge Wood and Judge Easterbrook play a little game. And they try to pretend that the text is not just an arm as something that can be used offensively or defensively, even though they quote that language from Heller and Samuel Johnson, the English lexicographer from which that definition is drawn by the Supreme Court out of that English dictionary in the 18th century. But then they go on to take all that historical analysis about in common use, which is a historical test, and elevate it to the text. And then they go on to say that the burden rests. The burden rests on the plaintiffs, the Second Amendment plaintiffs, to show that semi-automatic weapons are in common use for self-defense. BS! This proves my point. Judge Woods and Judge Easterbrook are not serious judges, and I mean that in all earnestness. If you can't figure out that the in common use test is derived from the historical analysis, and we know it's derived from the historical analysis, and why is that? Because in the Heller case, the Supreme Court says that the only conceivable historical regulation tradition in American life where some guns or arms of any sort can possibly be outright banned are those arms that are both dangerous and conjunctive, unusual. And that was based upon historical analysis done in Heller by the Supreme Court. And then they went on to say, therefore, if an arm of any sort is in common use by Americans for lawful purposes, it cannot be dangerous and unusual because it cannot be unusual. And by the way, the reason why it is so critically important that the historical test be separated from the text is because at the textual level, the Second Amendment plaintiff bears the burden to show that textually the modern-day gun control law or the action of the plaintiff that wants to take or has taken satisfies the text is on the plaintiff. But once that happens, the burden shifts to the government, and the government bears the burden to show that the modern-day gun control law they're trying to enforce is consistent with the longstanding historical tradition of firearms regulation in the United States. The burden is on the government. We always want the burden on the government. But here you have Judge Wood and Judge Easterbrook saying that the burden's on the plaintiffs. Wrong. 100% wrong. It's because they can't read or refuse to read Heller correctly. Now, why is it important that I just said the burden shifts to the government in an arms ban case at the historical level? Because it's not the Second Amendment plaintiff's burden to show that an arm such as an AR-15 is in common use. It's up to the government to show they're not in common use, which is impossible for them to do. So again, this is Judge Wood and Judge Easterbrook's first and biggest major mistake in this opinion. The second thing, of course, is that they then draw analogies to Bowie knife regulation. But as you know from this channel, Bowie knives were never banned in America. Bowie knives were simply regulated. The way they were regulated was how they were allowed to be carried. Not a ban, but these are bans of AR-15 semi-automatic rifles and magazines that hold more than 10 rounds. So again, the Bowie knife analogies don't even apply. But again, none of this is necessary because the Supreme Court already told the Seventh Circuit Court of Appeals how to deal with arms ban cases. The Seventh Circuit with Judge Wood and Judge Easterbrook simply are refusing to follow it because they don't like the result. They think they should be on the Supreme Court, so they don't want to treat the Supreme Court with the proper respect that other inferior court judges do, and under the constitutional system of government, they're supposed to do, i.e. respect your seniors, i.e. the Supreme Court when you are indeed an inferior court judge, which Judge Wood and Judge Easterbrook both are. The next obvious game involves Judge Wood's opinion, literally, in my opinion, taking out of context a quote from Nysurpa versus Bruin. Specifically, in their opinion, they talk about how that dealing with these kinds of guns can be dealt with because, quote, cases implicating unprecedented societal concerns or dramatic technological changes which may require a more nuanced approach. So basically, what's going on here is they're trying to rely on the notion that some of the issues they're trying to confront in this AR-15 case, magazine case, may be a case implicating unprecedented societal concerns or dramatic technological changes. But here's what's interesting. This is on page 23 of their opinion. Do you know what they didn't do? They didn't quote the most important part in many respects of that clause. Let me read the entire sentence to you. The entire sentence, though, was not typed in by Judge Wood or the Seventh Circuit. I wonder why. You'll see why when I read it to you. This is what the Bruin case said. The U.S. Supreme Court said this in discussing historical analogies. Again, when you're dealing with an arms ban case, you don't need to do any of this work because the Supreme Court already looked at the historical analogies involving arms ban cases and made their decision. In common use means we win, period, full stop. Okay? Nevertheless, I just want to show you how, in my opinion, this opinion by Judge Wood is not serious. The Supreme Court said in Bruin the following, quote, while the historical analogies here and in Heller, hear what I just said? This is very important. The Bruin court said, quote, while the historical analogies here and in Heller are relatively simple to draw. Heller's a gun ban case, yes? Yes. Yes, it is. While the historical analogies here and in Heller are relatively simple to draw, other cases implicating unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. See the problem? Here you have Judge Wood talking about the last half of the sentence. She's talking about cases implicating unprecedented societal concerns or dramatic technological changes, but conveniently ignores the first part of the sentence that says that unlike in Heller, the arms ban case that you're supposed to follow, you inferior court judges. Cut off, not used. Why? You tell me why. And I think we know the answer, because they either can't understand that first clause, or more likely they don't like it, and they're trying to sneak around it. And that's why they didn't quote it. Terrible, in my opinion. Terrible. Now, just to show you how silly this opinion is, this is their fundamental conclusion. Based on the record before us, which is like, hello, America, we are not persuaded that the AR-15 is materially different from the M16. Come on. One is a fully automatic machine gun. The other is a semi-automatic rifle. Now, what's interesting is the dissent makes a powerful point that we've talked a lot about on this channel. One wonders if they even pay attention to this channel, and that is that even Ruth Bader Ginsburg recognized the difference between a machine gun and a commonly owned AR-15 semi-automatic rifle in the Staples versus United States case. And what's interesting is the dissent here by Trump appointee Michael Brennan makes a big point of that to say, look, Judge Wood and Judge Easterbrook, this is not rocket science. We have the in common use test by Americans for lawful purposes. That is the test the Supreme Court gave to us for arms ban cases. In Heller is still good law. You admit that in your majority opinion. And we know from Staples, the Supreme Court case, that a machine gun, an M16, and an AR-15 are different, materially different, and that AR-15s are owned by millions of Americans all the time for just because they own them. This is back in 1994, by the way. Okay? Nevertheless, guess what? The judge says that, Judge Wood and Judge Easterbrook, who probably don't know anything about guns, it's pretty apparent the way they wrote this opinion, go on to say that we think they're the same. But here's where, you often ask me, Mark, how do these dots get connected? They get connected. They do get connected. Because on page 32 of the major opinion, this is of 95 pages, I should say. It goes on forever. This is very interesting. You see, we know the Supreme Court just granted cert in that Bumpstock case. Well, guess what? Judge Wood relied on involving Bumpstocks. I kid you not. Here it is in their opinion. The similarity between the AR-15 and the M16 only increases when we take into account how easy it is to modify the AR-15 by adding a bump stock, as the shooter in the 2017 Las Vegas event had done, or auto-sear to it, thereby making it, in essence, a fully automatic weapon. This is what I predicted. I predicted the anti-gun judges and the anti-gun lawyers are going to try to argue down the road that AR-15s and semi-automatic rifles can be readily converted into machine guns, and they can all have to be registered as NFA items, and they can all be banned. That's where the anti-gunners want to go. And here you have Judge Wood, a Clinton appointee, and Judge Easterbrook, who's bitter that he's not on the Supreme Court. Thank God he's not. All trying to play games, but they just embrace the bump stock thing, and you watch, the ATF bump stock ban is going to get tossed out and into the trash by the Supreme Court. So that's how these things sometimes come back and bite the anti-gunners and terrible judges like Judge Wood and Judge Easterbrook when it comes to the Second Amendment on the butt. All right, before I wrap up, I just want to make one point about the dissent that I think is very good. One point they make, that AR-15s are far more popular than the stun guns that the Supreme Court held are protected in Caetano. I think this is significant. I've talked a lot on this channel about Caetano. I've made it my personal mission to try to elevate the Caetano versus Massachusetts case involving stun guns, which, by the way, are not handguns. They're not firearms. They're something different. Elevating Caetano is to part of the pantheon of major Second Amendment decisions, and I think I've been somewhat successful with that. And now you have Michael Brennan, the Judge Michael Brennan, the Seventh Circuit, writing the dissent, pointing out that, hey, if 200,000 stun guns being possessed by Americans in Caetano is enough to be in common use and protected arms, then how the heck is an AR-15 that's owned by tens of millions of people, or magazines that hold more than 10 rounds owned by hundreds of millions of people? How are these not arms? They're obviously arms, and they're obviously in common use by Americans for lawful purposes. So again, I think the good news out of this is not a serious opinion. This is not anything that's going to be taken seriously by the U.S. Supreme Court, at least the 6 justices on that court that take the Second Amendment seriously. So the unfortunate thing is, of course, for our friends in Illinois, you're going to have to live under this for the time being. As to what happens next, I suspect what's going to happen is that one of the plaintiffs that lost this case in the Seventh Circuit is probably going to seek cert or seek some sort of intervention by the U.S. Supreme Court. I suspect it's possible that the Supreme Court could step in and do something with this case, because I think it's a pretty straightforward gun ban case, and I think they've already decided it. I could see it happening, but I think it's probably, unfortunately, more likely they're going to let this case go back down to the district court to continue to be litigated until there's a final judgment, and then go back up to the Supreme Court when there's a final judgment. Because just like in the Bumpstock case we just saw in Cargill, they didn't take the case a year ago when it was interlocutory mode. Now it's a final judgment. The Supreme Court took the case in Cargill involving bump stocks. I think that's probably going to happen here, although I would love to see the Supreme Court take it now. If I were on the Supreme Court, I would take this case now if I could, because I think it's such a slam dunk case. You take the Heller case in common use, you apply it right down the middle. It doesn't even have to be a very long opinion. This is really a slam dunk, and the Supreme Court has already determined the relevant law for arms ban cases. It simply just has to be applied to the obvious fact that these AR-15 semi-automatic rifles and magazines that hold more than 10 rounds are clearly in common use for lawful reasons by Americans, and there's simply no way the government can possibly overcome that. And it is the burden on the government to show they're not in common use. They'll never be able to do it, and it's a slam dunk to me that we win that case if we get it to the Supreme Court. And I know there's a lot of people on the anti-gunner side are desperately trying to keep an assault weapon case, if you will, getting to the Supreme Court, because I think it's a fait accompli. We will win that case if we can get it there, is my guess. Okay? All right, folks, hope you learned a little bit something here today. I wish I could bring you better news, but do not lose hope. The war is continuing, and this game is not over, nor is this case. And we will see you again soon here at the Four Boxes Diner. Don't forget to follow me on X at Four Boxes Diner. And again, see you soon at the Four Boxes Diner.
Orders up. Table 2A.